Hello and welcome once again to this 5PB webinar. I'm Andrew Johnson. I'm pleased to introduce today not only our two scheduled talks, but also a bonus extra. Miranda Moore, Queen's Counsel, will begin today with a general guide to cases involving baby shaking. She'll be followed by Catherine Pinnell talking about Section 41 of the Youth Justice and Criminal Evidence Act. And then Dominic Lewis will rejoin us to give a brief update on the amendments that came into force yesterday to the coronavirus health protection regulations. But I'm pleased to begin now by handing over to Miranda Moore, Queen's Counsel.
Hello. This is an enormous topic, and so what I'm going to do this afternoon may seem a bit of a gallop through the topic, but it's in order that you get the headlines when you have to deal with a case of this type. The position is that you will either be dealing with grieving parents because the baby has died, or parents of a very severely injured child. And so this talk is designed to give you starting points so that when you are dealing with a case like this, you have a ready guide material that's available for this talk will be in a package which Andrew Ross will have and you can get after the talk, because some of the documents I'm going to put parts of up on screen are too voluminous to show in slides, even though I do have quite a lot of slides. Could we have the first slide, please, Andrew? Now, the first slide is headed starting points, and whether prosecuting or defending in a case like this, go to the CPS website. It does have a lot of useful information, both about how charging decisions are made and where you should look and what you should look at. The second highlight on this page is get appropriate representation. Now, it's easy for me to say that from my position, but the Court of Appeal have been scathing where people have had representation which has not been of sufficient seniority or with sufficient background knowledge. Do not embark on a case like this until you have a team ready and willing and available to go who are going to know what they're talking about. The third point on this slide is read the Finesse Report. If you don't know what the Finesse Report is in relation to shaken babies, really you should not be doing one. The second item under that little icon are the 2016 guidelines, which were guidelines which were put in place after a lot of consultation, and Baroness Kennedy was partly responsible. So if I call them the Kennedy guidelines in future, you'll know what I mean. Both of those things are available online, and available by link through the package that Andrew Ross has. The third icon is understand the science. In the words of Donald Trump, I am not a doctor, but for the purposes of one of these sorts of cases, you have to know what the doctors are talking about. And the fourth icon on this page is what I call remember the humanity of the situation. Grief and blame are very large in witnesses in cases like this. You will find that the partner of the person suspected of committing the offence, be it manslaughter, murder, or some form of serious assault, will be in denial. This will be for two reasons primarily. The firstly is because they will never be able to believe that the person that they entrusted their child to has done this. And secondly, if there are concurrent family proceedings, they will not want to accept or even say that that person has done this, because it will reflect badly on them, and social services might then take action to take the child away, even though, if the child is living obviously, or any living children away, even though that person has not actually injured the child themselves, on the basis that that person has not had a safe place for the children to live. So you have to remember the humanity and the human frailties that this sort of case will expose. Now, next slide, please. You will hopefully now see the headlines of what I call the Finesse Report. Well, what was it? Well, anybody who has had anything to do with baby shaking cases will know that in the early 2000s, there were a lot of disagreements going on as to what the science meant, whether a particular set of symptoms or findings known as the triad meant one thing or the other. And there was some pretty vitriolic arguments going on between experts. The Finesse Report was out of a meeting, as you can see, that was held in December at the Royal College of Pathologists. Peter Finesse was the chair and he wrote the report. And if we go to the next slide, you will see why I say it's well worth reading. Just look at the sort of people who were there. Anyone that's done a murder case will recognise Dr. Al-Siraj, who's at the top of the list. You will recognise Bonchek, who is the eye expert, Nat Carey, well known to most of us, Duplessis, going all the way down, Irene Scheinberg, and then if you look at the second column, one of the people over which there was quite a lot of argument, second name down. Now this report, I have put the link in full on the package and it's well worth reading. And if you look at what I've put in red on this slide, he acknowledged that the fact that this subject has previously generated heated arguments. The meeting probed the science. It came to conclusions and those people listed agreed with them. So if you see one of those people giving a different opinion in your case, you can hit them with the Finesse Report. And so it is well worth a read. Next slide, please. The more recent report, the one I've called the Baroness Kennedy report, is in 2016 and it's more wide-ranging. It's a multi-agency guideline for care and investigation. And it goes through the steps that will be taken by all sorts of agencies, from the police to social services to the National Health Service, when a child is injured. And again, it's well worth reading it. It may just be something you skim read for a particular case, but be aware of it. And again, the link, as you can see on this slide, you will be able to get later. So when you are doing one of these cases, what's the first thing that is really useful for you to do before you even get into the minutiae of the case? Next slide, please. The thing that you've got to become aware of and be able to understand without keep having to ask somebody to explain it are the technical terms that will be used. Do you know what those terms mean? The cases involving deceased babies particularly, and some that survive, involve CT scans and MRI sequences. Did you know that that's what CT stood for? A CT scan is fine for an overview, but for finer detail in the brain, you need an MRI scan. Not all hospitals have them. You may find that the child is transferred to a specialist unit to get an MRI scan. The different planes through which a scan is taken, coronal, sagittal and axial, are, if you like, through the ears, through the nose and through the waist. You need to know those sorts of things. So make yourself a glossary of technical terms so that you know what people are talking about. Next slide, please. The next thing which you should prepare, and this will go into the jury bundle, and I've on my fourth bullet said it should be the first thing in the jury bundle after the indictment, is the glossary of medical terms. Now by that I mean any term that appears in the reports. You may be used to reading doctors' terminology, your jury probably won't be. Put them in alphabetical order, send them to the defence or put them up on the digital case, get agreement about them. Once you've done that, then that is a ready reckoner that anybody can refer back to in the case. I've got a stock one, and if we go to the next slide, you will see the sort of things that I put in my stock one. I've put my full stock glossary in the package so that anybody can download that after the talk and use it. Feel free, add things, take things out. Most of it has come from medical dictionaries or where I've asked somebody in the past for a term to be explained. So that's your glossary of medical terms. But if you're like me and you find pictures paint far better description of things than words, then you're going to want useful diagrams. Some experts say, oh no, I don't need a diagram. I will perfectly be able to explain myself. They might be, but I've never done one of these cases where I haven't found a selection of diagrams, often thieved from the internet, are the best way of explaining something to the jury. Can you point out where the subarachnoid space is far more easily done if you have a colour diagram. So could we see the next slide, please? Useful diagrams. You can find these on the internet. Some of your experts may provide them. The brain, you need a general overview. You need the lobes of the brain set out and labelled. You need the blood supply and you need the meninges set out. The skull, you need the different sections of the skull. You need it from different angles. And if your child has injuries to the skull, you need to be able to work out yourself exactly where those are. You don't always get a diagram from the pathologist. Eyes. Get eye damage examples. The retina at the back of the eye was described to me once as being like a piece of laminated wood. In other words, it has lots of layers. When it is damaged, it folds. In other words, the top layer will bubble and you get something known as a perimacular fold. These things are often seen in traumatized children. They're described. I've had an expert describe some of them as looking like little volcanoes. They are when the layer has been pulled away from the underneath layers, blood gets in and pumps it up like a little, it looks like a little volcano with a flat top. Those are indicators of traumatic events and they're very important, and it's very good that you can explain that with a diagram. You also sometimes see white dots in retinal hemorrhages. You need to have an example of that in your library of useful diagrams. A diagram of the spine, pointing out which vertebrae are which, is also very useful, particularly if there are injuries in that area. And then a skeletal diagram. Not all babies who have been shaken and have shaken baby injuries have skeletal injuries, but a lot do. You will often hear in non-accidental injury in children the expression bucket handle or corner fractures. These are where there has been a pulling or twisting, which is extremely violent and extremely sudden. Bucket handle fractures are non-accidental injury markers. It's very difficult to understand how you could do that to a small baby without using a lot of force. You will often hear the expression not within normal handling. Now, I've put down the bottom of this slide the Salter-Harris fractures classification. And if you look at the next slide, you will see a little, I think it's probably a student diagram with why it's called Salter-Harris. And the letters coincide with how the break occurs. So number 1 is S for straight across. Number 2 is above the growth plate, so that's the A. Number 3 is lower, hence the L. Number 4 is through everything, hence the T. Number 5 is what you would call a crush injury or erasure of the growth plate. The growth plate is what you would find at the end of a small person's bones because they're still growing. So E for erasure. And then the last one, type 6, is incredibly rare. That's the chip out, or what they call a reaction periosteal. Don't see those very often. Looking at the diagram that you've got, straight across you will see in about 5% of cases. above the growth plate 75%, lower 10%, and through everything 10%. The through everything one is a crush injury, not one of those nasty twisting injuries. Understand when somebody says they've seen a bucket handle fracture that you are looking at what I will call an extra piece of evidence, and I'll come back to why I say that's important in a moment. So let's go to the next slide, please, which I've entitled Experts. You will have experts coming out of your ears in a baby shaking case. The first point I've put on this slide is experience. Now, what I mean by that is, are you looking at this expert statement as an expert witness in the true sense of the word, with a duty to the court and a proper statement of expertise, or are they an expert in paediatric medicine of some fashion who was a treating physician of the child? Because often a baby or small person will be taken into hospital and treated. They may survive, they may not. But the treating physician is not going to be your expert witness, and you must make sure you delineate between the two when considering the evidence. A treating physician can ultimately be very, very helpful. They deal with the parents, they deal with how the child presents, they deal with immediacy, and they deal with things that happened very shortly, normally after whatever caused this to happen. Expert witnesses often come on the scene much later. They are reviewing records, slides, photographs, MRIs. They very rarely see the child. The second bullet point I've put is current clinical experience. There was a time when the expert that you rolled out in this area might have been brilliant in his day, but had now retired and was earning an honest crust by coming along as an expert witness. Current thinking is that's not good enough. One of the ways that you can criticise an expert is that they are not current. So please make sure your expert witnesses have current clinical experience. My third bullet point, I put previous, and nothing wrong with Google. Check up on an expert you are offered. Google them. Make sure they haven't been front page headlines in the Sun. Sadly, some experts that come forward do not help themselves. They say things in other cases. You would need to know about that, because if you don't, the other side undoubtedly will. Next bullet point is conference. Hopefully you will have the luxury of a conference with your expert. Keep notes. Keep notes for two reasons. One, because it is a very good idea to email your expert afterwards and say, these are my notes of our conference. Please could you confirm that I've got this right, and responds. That is because sometimes an expert will happily tell you something in a conference, which when it comes to court, they have forgotten they told you, or say something slightly different. It's very useful to say, I've seen your statement, I'm sure you'd like to remind yourself of it, but here are the notes of the conference, and perhaps you'd like to look at those as well. And the second reason you keep the notes is for disclosure purposes. If your expert says something different or something that might assist the defence, if you're prosecuting, then there is a requirement to disclose it. Equally, if you have a conference with your expert when you're defending and he's giving you a wonderful statement, it would be very unwise to rely on that if he tells you something different in conference. The next point is agreement. Now, I've put the CPR 19, particularly 1962 there, because generally speaking now, experts should get together before a case and come to a stated position on what they agree and what they don't agree. It's not good enough anymore for, if you're defending you or if you're prosecuting you, to let somebody think, well, I'll just have a pop at the expert on a few topics. I haven't really got any disagreement with him, but it might put a bit of doubt in the mind of a jury. Any judge worth his salt will stop that happening. So agreement is essential, and the list of points on which they agree or don't agree, again, will help everybody, including you. Beware trial by expert. Well, what do I mean by that? It will be important, whichever side you're on, to get an idea of what caused the injuries. How much force? How many shakes? This is where the problems lie. Experts are loath to give certainty on this for the very simple reason that nobody, or we hope, nobody will ever conduct experiments on babies. People try carrying out mechanical experiments, and you see sometimes physics coming in with forces and diagrams and trajectories and things like that. But you can't test this out on a baby. And so what force is required is a very, very difficult thing. What experts will often say is, the injuries I saw have been caused by this particular mechanism. They will say, the injuries that I saw are not the results of normal handling of an infant. They are not the results of rough handling of an infant. If that were the case, we would see these sorts of injuries day in, day out, and we don't. Occasionally, when the injuries are particularly bad, an expert will say, or may say, these are the sorts of injuries that I would normally see when a child's been in a high-speed road traffic accident or had a fall from a great height. Sometimes there is criticism for experts who say that sort of thing, because each person, as we all know, is different. We all bruise differently, we all bleed differently, we all heal differently. And so care needs to be taken. Often it is better for an expert simply to say, the last time I saw injuries like this, it was because I knew X happened. For example, I knew this baby had been shaken for whatever reason, and that baby and this baby have the same injuries. A comparative, but you need to be incredibly careful. I've put their diagrams or your stock pictures. It's worth showing your expert the stock pictures and the glossary that you're proposing to use and ask them whether they agree with them. I've put remote working, and again, we're all getting used to that now. The dangers are that you've got to make sure that the expert has everything that the jury have, and sometimes it's quite difficult to get things to them. But the benefits are that you can call people who don't want to come away from clinical practice. If they've got current clinical experience, they're the best ones to come to court and sit around. So remote working is a real bonus these days, which you can sell to your expert. Could we have the next slide, please? This is the triad, the three things which are looked for non-accidental head injuries or shaken baby. The subdural hemorrhage, which is a hemorrhage over the surface of the brain. And please note it's subdural, not subarachnoid. The different layers of the brain, so make sure you've got the subdural hemorrhage. The second, encephalopathy, which is a posh word for something abnormal in the brain. And the third is the retinal hemorrhages, the hemorrhages at the back of the eye that I talked about earlier. Those are the three limbs of the triad. If those are three present, then on the face of it, you have a shaken baby. However, there have been historically challenges to the triad. Next slide, please. And you will remember me pointing out one of the names on the Finesse Report. Between 2000 and 2004, Dr. Geddes, leading a team of professionals, challenged the triad, saying that there was one unified cause of the three injuries, but not necessarily trauma. It was known as the unified hypothesis. It was, they said later, intended only to promote discussion, but it's well that you are aware of it, because a lot of the time people will latch onto it and say, oh, the triad, that's not necessarily shaken baby. Be aware of it, but we have moved on. Next slide, please. I said at the beginning of this talk that it would be useful to go to the CPS guidance. If you do read it, it says that it's rare that a charge of homicide or attempted murder or assault could be sustained where the only evidence available is the triad of pathological features. Such evidence is rarely conclusive of non-accidental head injuries, and prosecutors should look for other supporting evidence. Well, what should you look for? You look to the eyes, particularly. For the retinal folds, you remember me describing them as looking like little volcanoes. Axonal damage, in other words, nerve damage that you might see. And the other thing that you might see is a cleft in the brain. Now that sounds horrible, mainly because it is. You will see on an MRI scan a dark fissure in the brain, which is often caused by a child or baby being propelled against often a soft surface and then stopping abruptly. And because the brain is held in the skull, it moves and then stops, and then there can be a cleft in the brain. One of the most jury-friendly experts describes what happens when a baby is shaken or thrown onto a soft surface as considering an egg in a cardboard box being held in place simply by overcooked spaghetti, which are the blood vessels. And when the box and the egg stop suddenly, the spaghetti severs and that lets the blood flow in. And those sorts of visual, impactful things are the sorts of things that you've got to be thinking about. But those are the medical things. I was quite surprised that the Kennedy guidelines in 2016 put some other things in, which personally I'm less keen on looking at to say that this is a case that should go forward. I would rather see something current to the child you are considering. However, I bow to those that have done a lot of research into this, and these are the list of things that might tip it from just triad into prosecute. Previous sibling deaths. Most of you will be aware that we have to be a bit careful about coincidence after Sally Channing. Delay in seeking help. Again, I'm less keen on that. People do panic when things are wrong with their children. Everybody does it naturally. Inconsistent explanations. Again, I'm less comfortable with it. Unexplained injury, either present or previously. Yes, one can see that immediately, should warn everyone. Evidence of past or present drug and or alcohol abuse. Again, just because you're a drunk doesn't mean to say you assault your kids. Neglect, obviously. Previous convictions of parents or partners, in particular violence towards children. That one I think you can probably all understand. And then previous ongoing child safeguarding concerns. Again, it depends what it is. But that is the guidance and taken from the Kennedy guidelines. Moving on to the next slide, please. What will be important when you do one of these cases is to establish a timeline. Timing is everything. I'm just looking to see how long I've been going. I think I'm still all right. Firstly, look at external evidence. By that I mean telephones. When was the 999 call made? Can you tell when somebody was using a digital piece of equipment? I've had cases where the reason that a baby has been killed was because it interrupted the male in the household watching online porn, and we could tell when the film was stopped. Horrible, but it does give you timing. That's external timing. I've then written the problem with bruises. Most of you will already know that to age a bruise is all but impossible, but you will also know that bruises do not, in their true sense, take place after death, after the blood has ceased pumping. The next thing I've put is iron pigmentation. Most of you will know that the reason we're all living, breathing and working is because we have red blood cells pumping around our body, taking oxygen to all our important bits. When red blood cells break down, you get iron pigmentation, and the breakdown and the amount of iron pigmentation is a good clue as to how old a bleeding injury is. So that's something that you should be aware of. I've also put macrophages, They are the body's scavengers. They eliminate cellular debris. And so when blood cells break down, so you have a bruise, it's breaking down, you've got iron pigmentation, but you also have these little macrophages which whiz along to cart off the debris. And so the presence of those shows that healing has started, or the body's healing process has started. So if you can see them, obviously not with your naked eye, then you know that the child has lived after the injury, even for a small period of time. Then you've got healing in bones. Part of looking at the triad and whether there's anything plus the triad is to see whether there's any evidence of previous injuries. Very young children heal very much faster than adults. You probably are aware that children's bones are incredibly pliable, and if you think of them like the sapling on a tree, you will know that they take quite a lot to break, but they do also heal much faster than we do. Next slide, please. Exclude the possible. Look to explain the injuries another way, particularly if you are defending. Look at the history of the child. Find out about the birth. Was it traumatic? Was it forceps? Get the child's red book. For those of you that haven't had kids, you won't know what a red book is. It's probably digital these days, although back in my day it was a small plastic book. It charts the baby's progress. The health workers write things in it. The mother writes things in it. The hospital sends you away with it. Those are important because of what was seen in life. How was this child? Was this a healthy baby? Was it a sicky baby? These things are incredibly important because when you come to look at factors that you need to exclude, things that might have caused bleeding in the eyes, things that might have caused swelling in the brain, you have to look at how that baby was in life. Babies don't suddenly get a rare blood disorder on death. They show some symptoms of it beforehand. They show bruises earlier, all sorts of things like that. So what was seen in life? Then look at the first explanation given, possibly to a 999 responder, because if there has been a disclosed injury, in other words, I came downstairs and found the baby had climbed out of the cot and was on the floor and was all floppy and wasn't moving. Look at those explanations, because those are one of the things that must always be taken into account when considering whether to allege shaken baby. The first tests that will be done at a hospital are bacteriology and virology. Has that child got sepsis? Those tests are routinely done, so do not worry that they haven't been done. They will be routinely done, but just make sure you've looked at them and checked the results. They will also check for a whole host of things these days. There's almost like a checklist. They will look for cancers of the blood, metabolic disorders, Ehlers-Danlos type 4. Now, what's that, you may think? It is a collagen disorder, and it means that you are able to bend your joints very much more freely than a normal person because your collagen is that much more elastic, and it can lead to what might be seen as abuse type injuries, or what might look as abuse type injuries. The doctors will look for an intracranial aneurysm, that bursting of a tiny blood vessel in the brain. Was there something like that present? They will look for genetic issues, particularly bleeding disorders or osteogenesis imperfection, which is a bone disorder. They will look for vitamin deficiency these days. Some of you may remember, I think it's probably about 10 years ago, there was a case at the Old Bailey involving what was said to be non-accidental injuries in some children in a family, and it turns out they had rickets because they had a vitamin deficiency. You will want to look at sodium levels. A warning here, the first thing if a baby is surviving any length of time is when they get to hospital is they're put on a drip, which is a saline drip. So that can muck up the sodium levels, but it won't come as any surprise to you if you've got children, and probably if you haven't, that you can't give salt to a baby because mucking up a baby's sodium levels will kill it. And so if a baby has some form of electrolyte disorder, a naturally occurring one, or from a disease which has mucked up its sodium levels, that can cause pressure in the brain. So again, be very careful, make sure it's been looked at. I've then put a CPR artifact, ribs and reperfusion. Those of you that have done murder cases will know that the enthusiastic efforts to try and revive somebody will often in an adult fracture ribs. In fact, I think the statistics show in 45% of cases where enthusiastic CPR has taken place, there have been rib fractures. That can also happen with babies, but obviously they have more pliable ribs and it's not necessarily the case. Reperfusion is where the blood which is being pumped manually by somebody could, and I emphasize could, be pushed upwards into the brain, therefore causing what might look like injuries in the brain or blood into the brain. And the other thing that is sort of a CPR artifact is what's known as Terson's syndrome, which is where the brain is bleeding, and that bleeds because of course the eye and the brain are connected into the eye. But again, doctors will have considered it. It's just to make sure that you've considered it as well, and you can say to some possibly over enthusiastic solicitor, ah, well, it's been looked at and it's definitely not that. So go through that checklist and be able to say to the jury, if you're prosecuting, or be able to say to your client if defending, look, they have checked off this, 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 this and this, and it's not what killed your baby or the baby. So that is a whistle-stop tour. I'm going to finish with the last slide, which is the coroner, because when you are involved in a case like this, you may quite unexpectedly get a telephone call from somebody who introduces themselves as from the coroner's office. They will want to know whether you're prosecuting or defending when they can sign off and allow the baby to be buried. You will see there that the Home Office circular states, in the interest of justice, the defendant has to be offered the opportunity to arrange an independent examination. That probably goes without saying. Current guidance is that that should take place within 14 days, and most pathologists will undertake to do one within a week of instruction. So please be aware that the coroner is somebody you may have to deal with and be ready to do it. So have that difficult conversation if you're defending with the family about a second post-mortem. That concludes all I'm going to say about this. As I say, it's a huge topic. I could go on a lot longer. The final thing, and somebody raised this with me after I'd done the slides, was liaison with the family courts. There is a very good guideline out there, and I've put it on my paperwork so that you can look at it, which runs through how the two court systems interact in cases of non-accidental injury to children. But just be aware, family courts are there to promote families, and they are to promote people telling the truth. And therefore, if somebody makes submissions in the family courts, they are protected and you cannot use them in the criminal courts, no matter which side you're on. Thank you very much.